Oh, I did remember that without even writing a note to myself. That's pretty remarkable. Notes are big.
Mhm.
We have so many ways to remind ourselves of things now. There's very little excuse to forget anything.
Mhm.
All right. My computer tells me it's 3:01, so we are gonna get going. So welcome to our group on the webinar today. This is one of our monthly client update meetings. We always try to do one or two during the year as a webinar for those who can't easily get to our office. So hopefully this will be a useful exercise for everyone. And for those of you who have participated in the past, which is probably most of you, you sort of know the routine, and we're going to give you a little update on what's going on in the world of estate planning and elder law right now and within the firm and just as a general proposition. So with that being said, we're going to start the PowerPoint here. Let me click on that. There we go. So we always like to sort of update people about what's gone on within the firm.
Rich, if you want to just share the
Oh,
PowerPoint.
did I not share it yet? I'm sorry. Okay, well, that's good that you're there to tell me. Okay, here we go. I forgot that all important sharing. Is it up there now?
Yep, that's that.
All right, thank you, folks. All right, so you haven't missed anything. Here's the first substantive slide other than the cover slide. Okay, so going back to my premise here, we'd like to update you about the internal workings of the firm, how it relates to our practice. So this past February, we were joined by a new legal assistant, Dominique Dawkins, who's an Orange County resident, and she is really, we create a new position, essentially an attorney or a legal assistant position to specifically manage the client maintenance program. That is her primary job, along with getting documents ready for signing. So we expect Dominique will be your primary point of contact for the maintenance program under our supervision, of course, but she'll be the person to arrange your update meeting signings and the like. She's a delightful young lady, and I think you'll enjoy meeting with her as you have with us over the years. Um, we do have a new attorney starting just about 8 weeks from now, I think. He's
Mhm.
diligently studying for the bar exam. His name is Max Sears. He's a native of Carmel over across the river, and he just graduated from Cardozo Law School. He seems like a very ambitious guy about trust and estates work, and he's actually in the fall starting a master's in tax law program remotely at Georgetown Law School. So we have high hopes for Max. And on the downer note, Mavish did leave our firm in February. She was moving down closer to the city, and a firm in White Plains swooped in and took her from us. So those things happen, and we're sorry to have seen her go both personally and professionally. But time marches on, and we will proceed apace. Um, so that's sort of the firm news. There's the other blow our own horn kind of thing. We have some of the accolades we've received over the past year. Super lawyers, both Megan and I were honored by that publication. And several of our attorneys in the firm were named on the next page, I believe. Oh yeah, Megan's still a rising star. I'm a fading star. She's a rising star. So we're going in different ends of the spectrum. But several of us in the firm were named top lawyers in the Hudson Valley by Hudson Valley Magazine, and that's always a nice uh, pat on your back kind of situation. But from your perspective, hopefully it gives you comfort to know that you're working with the people who have peer respect from the peers and the legal community and the greater community as a whole. Without that being said, let's talk about some of the document updates that we've incorporated this past year. So Megan, go for it.
Sure. And so as most of you probably know, I think all of you have participated in this from year to year. We're always trying to improve the documents that you have, and that's one of the benefits of participating in the program. Even if you don't have changes, we want you to come in and update your documents so that you can take advantage of some of the newer planning options that might be available or some of the newer language that we're using. We're always trying to improve. So just a couple of changes in the documentation or new options that are available depending on the kind of plan that you have. So this year, most of those changes are applying to our revocable trust structures. So whether that's your standard revocable living trust, also revocable is your retirement plan trusts for those who have them. And so one of the newer, not a new option really, it's always sort of been available, but something that is easier to incorporate in your planning now is what's called a dynasty trust for your descendants or other beneficiaries. And this is one of those options that you typically don't have to know to ask for this. This is something that we would discuss with you as part of your planning strategy, either at the outset or on a year-to-year basis. So certainly something that's coming to the forefront again this year. The dynasty trust structure is where we can allocate the funds to your beneficiaries as part of their inheritance in a trust that is more appropriate, I would say, for people with maybe higher net worth estates, in the sense that they're worried more about estate tax planning and kind of helping to mitigate some of that estate tax. Trust structures for beneficiaries are always going to also provide us with levels of protection for those beneficiaries as well. So if this is going to be something that we feel like might be appropriate for your situation, we'll bring this up during the update meeting with you and say, you know, maybe this is something we want to consider. We want to add it in as part of your planning strategy. The next bullet on this slide is talking about an additional provision that we are including in our revocable trust structures. It's going to be towards the back of the trusts in your trust administration articles. And it's a provision that just more specifically describes how maybe a beneficiary or any person that you've allocated what's called a lifetime power of appointment, how a person who's the recipient of that power of appointment can go about exercising that power. So in some instances, in all of your trusts, you're going to have some form of a power of appointment. And we already have some language in there about exercising specifically testamentary powers of appointment, which is more common. But also if we do include what's called a lifetime power of appointment, there's going to be more specific language to that. Powers of appointment generally, it's a very technical term, but generally what it authorizes a person to do if they're given the power of appointment is to actually change the distribution path of assets. So for instance, if you've given a beneficiary a general power of appointment, so you're leaving funds to a child, but you say, I'm going to give these assets to you, you have a general power of appointment over them, that's giving that child the ability to say where those assets should go when that child passes away. So when we do our planning with you, we typically talk about it in the sense of, you know, where would you want it to go by default? Maybe it's to kids, then grandkids, great-grandkids through the bloodline. But then we'll ask, do you want to give your child the ability to redirect this? If they wanted to leave it to their spouse instead or a charity instead, and based on your answer, we'll build in some power of appointment provisions, that ability to redirect the estate. So this bullet item is just describing that later in the trust document, if you've granted this specific kind of power of appointment, we're going to have some instructions on how a person would go about exercising that, just to be a little bit more clear and concise, to leave a good level of instruction for anyone who might need to use it.
Yeah, and if you're interested in revisiting what power of appointment you've granted, say, to your kids, in your trust instrument, go to the article that provides for the disposition for your children when you have passed away. And it's the last section of that article will describe the power of appointment. Many I would say the majority of our clients give a general power, which allows your child to leave to anyone they want. A fairly large minority is a limited power of appointment, which typically restricts to your bloodline only. And you may look at it now and says, "Oh, I don't want to restrict them. Let's give them a general." Or you may go the opposite. "I really don't want to give them a general. I want to go limited." And if you do make that determination, just let us know in your review worksheet when you have it. They want to change the power of appointment. We can do that easily and have a discussion just to confirm what you're looking to do.
Right. And then the next bulleted item applies to our joint revocable living trusts. So typically between a married couple, if they've done a joint trust, which is more common today than I think it was really years ago. In those joint revocable trusts, after the first spouse passes away, the trust itself directs the assets to be divided up amongst a few different trust options, depending on what the situation is at the time of the first spouse's death. But included in those options is what's known as the survivor's trust, where usually about half of the estate at least is going to be allocated to the survivor's trust. And updated in this language, and what the bullet item is talking about is amending some of the language regarding the survivor's trust and the surviving spouse's ability to make changes to that survivor's trust. Their ability to amend it, revoke it, but now even and also in addition to that, restate that trust. So just the ability to have continuous options for flexibility and changes in the planning that might be appropriate for a surviving spouse. It's not necessarily going to be language that we want to include in all of the survivors' trusts, because as you know, everyone's situation is different. And so there might be instances where we don't want to allow a survivor to do any kind of revocation or minor amendment. But for the most part, across the board, the survivors' trust is going to include these options.
Right. Okay.
And then the final one is regarding the retirement plan trusts. And so, and I would just actually say maybe retirement assets more broadly. In our trusts, we are finding that we've had to tweak our retirement language, our retirement provisions over the last several years in response to the Secure Act. And that happened, and we've been talking about it for 5 years now. That happened in 2020. And then additional guidance and amendments to the legislation have happened over the last 5 years. So finally, at the end of last year, we saw what we're expecting is the final Treasury regulations on the Secure Act. And now that we have that final legislation in place, we've been able to tweak and update our retirement language in each of our documents to conform with that new Secure Act legislation, or newer. And so now we think we have the final iteration of that. As we said at the start of this, we try to update things year to year. So we might improve upon the language and things of that nature. But what we're expecting by and large is that this is the final iteration of the Secure Act. And so we have broad strokes, the language that's going to be most appropriate for retirement funds, especially those retirement funds payable through your trust instruments.
Right. And the Secure Act was first enacted in 2020, so it's been 4 years of back and forth and proposed regulations and tweaks and so on until they finally came out last fall with the final regs. And it has been, in some ways, it's definitely easier to plan with the retirement assets than it was before 2020 or before the final regs came out. On the other hand, it's a little less favorable for most people in terms of the assets passing to their heirs, but it's easier to do it in a trust than it used to be. So there's some trade-offs with that. So those are the document changes for this year. We always like to update you about the legislative and regulatory changes that are either have occurred or we project to be occurring in the next year. So we'll go to that. Well, one thing I forgot to mention is if you do have a question, there is a Q&A tab or box on your screen, so you could always type in a question. We'll be happy to answer it before the end of the webinar. So as far as the estate and gift tax exemptions go for 2025, we have seen an increase of $380,000 in the federal exemption per person, just under 14 million per individual. For married couples, effectively, you can leave $28 million free of estate tax. While my note, or our note here, says beware of a possible sunset in December of this year, which is still on the books, if the, what do they call it, the beautiful big act or whatever the nonsense they have entitled in the
Big beautiful
the
bill or
law um, does go into effect, that would make permanent the current estate tax exemption indexed for inflation. So in 2026, we'd be looking at well over a $15 million per person exemption amount is what I understand would be. So the reality is, under current and likely ongoing federal law, the exemption will still be well beyond 99.9% of the population. Even if it sunsets at the end of this year, you're still looking at about a $7+ million per person exemption, still well over 99.5% of all estates. The New York State estate tax exemption in 2025 is $7.16 million, which was also an increase of a little over $200,000. So for a New York married couple, you can leave just over $14.3 million free of New York State estate tax. Unlike the federal law, New York, you have to make sure the assets are equitably allocated between spouses, because if everything passes automatically to the surviving spouse by joint ownership, or just it says in my will, I leave everything to my spouse, the deceased spouse's New York State estate tax exemption will be forfeited. Federally, we have the concept of portability. It doesn't matter anymore. But for New York people, married couples, we have to make sure we plan for that. The gift exemption has been increasing for many years. Over the last decade, it's gone from 10,000 per year, which some people still have stuck in their heads as the annual gift exemption amount. It is now in 2025 up to 19,000 per beneficiary. Simply means that you can leave to make a gift to any person, doesn't have to be a relative, of up to 19,000 per year in cash or in other types of assets, without having to file a gift tax return and without utilizing any of your lifetime gift tax exemption. The lifetime exemption is, get my pointer going here. The gift and estate tax exemption are the same number. So if we look at a gift of $29,000 to a child, for example, in 2025, the first 19,000 will be exempt. The other 10,000 will reduce your then remaining federal estate tax and gift tax exemption to 13,980,000, assuming you haven't made any other taxable gifts. So no one, and I use that term pretty strongly, is paying gift tax anymore, right? Because unless you've made gifts of almost 14 million above your 19,000 per person exemption, you're not paying gift tax, but it can whittle away at that number. And one other thing we always like to point out, Megan would have reminded me or said it if I didn't say it, is that Medicaid gifts are not impacted by the gift tax number. If you give $19,000 to each of your 5 kids, which is just under 80,000 or $100,000 of total gifts, it may be exempt for gift tax purpose, but if the next year you go to a nursing home, there is going to be a penalty period imposed for that gift for Medicaid purposes. We have our whole final module, our planning spotlight about Medicaid rules. We'll discuss that again at that point. So that's that. Just one other final piece on the changes in the law. Since 2020, we have been waiting for, and it's been statutorily enacted in New York, for the imposition of a penalty period or a look back period that would result in a Medicaid penalty for community Medicaid recipients. Presently, you can transfer all your assets to a non-spouse, because spousal transfers are always exempt. You can transfer them to a non-spouse and get community Medicaid pretty much the next month. if this 30-month look back is put in place, there will be some penalty associated with transfers made within 30 months of applying for community Medicaid. The tricky part here is it's a lot more complicated to figure out the system for doing penalties in a community Medicaid situation, given a lot more fluidity than if someone's in a nursing home. And therefore, the Department of Health, which is where this policy would be enacted, has yet to implement a 30-month look back, even though it's on the books. They have to pass regulations. They also have to get a waiver from the federal government for doing all this. So, Megan, you haven't heard anything new on this front since we started this year?
I haven't, nope.
No. So, of course, as we always have and always do, we'll keep you apprised if this changes. But for now, it's status quo, no penalties for community Medicaid services, which is a big one because most people want to be cared for in their home or in assisted living, and those are all community Medicaid locations. The only institutional location is actually a nursing home, not assisted living. So for those assisted living facilities that participate in the New York State Assisted Living Medicaid program, we can still do large asset transfers without creating a penalty. So those are the regulatory rules. I think that will take us to our cases of interest.
Mhm.
So Megan will tell us the first case, and I'll probably do the second. We always like to pick a couple of interesting cases related to estate planning and elder law, and I think we got a couple again this year that are very interesting facts.
Mhm. So the first one that we'll go over is the estate of Pierce. In this instance, there was an individual, woman that passed away in 2019. She was survived by both of her children, son and daughter. And her son and daughter were named in her will as her co-executors, which is pretty common. So this part is not out of the ordinary just yet. The will was admitted to probate. What that tells us is that this individual owned assets in her name alone at the time she passed away. She probably doesn't seem like she did any trust planning or anything like that. So because of that, no one can gain access or ownership over those assets until the will is submitted to probate. So in this case, it was. And the children were appointed as the co-executors. And thereafter, the children filed a request with the court for what's called a construction proceeding. And in this instance, and in every instance where there's a construction proceeding, what that tells us is that there's a provision in the will that is maybe at dispute, that people are interpreting it or could potentially be interpreted a few different ways. And that's what's happening here. So the children in this case end up disagreeing about a provision in the will, and they're asking the court to weigh in on it, give us some explanation or interpretation for what was intended to happen here and how we need to follow the will, the guidance, okay? So in this case, the will had some provisions in it regarding some real estate. There were several pieces of real estate. And the will specified that the daughter, Holly, was to receive, and this is the language in the will, my primary residence at the time of my death, which seems pretty straightforward in most cases, right? But obviously in this case, there was some question as to what's considered the primary residence. So the question that's posed here is regarding an adjacent lot. So a lot that's next to what everyone agrees on is the primary residence, and whether or not that adjacent lot is going to be considered part of the primary residence. And if it is, it's going to be distributed to Holly. If it's not, it's going to be shared by the beneficiaries. And so that was the disagreement. As we can imagine, Holly feels that the lot is intended to be included with the primary residence, and then the son feels that it was not intended to be included and he should share in the ownership of that separate lot. So here the court took a lot of things into consideration, and what the daughter presented was that for the more than 50 years that her mom had that property, she used the lot as part of her residence. So it turns out that this lot is, like we said, it's vacant, but there was like a nice garden area. There was a little bit of a paved area for some additional parking. And what the daughter described, at least according to the case, is that mom really used this as almost like just a very large yard, okay? And so it's an extension of her residence. And this is in Kings County, so we're imagining like a large brownstone with really nice open space around it that's nicely kept and things like that. So the daughter also presented that the description in mom's deeds included a description of both the home and the lot, and that over mom's lifetime, she took out several mortgages against the home, but the lot was also used as security for those mortgages. So anytime she took any kind of mortgage against the property, she actually was mortgaging against both the primary residence and this adjacent lot as though they are one. At least that's what the daughter is presenting. The son, though, said that the residence and the lot were assigned two separate tax parcel numbers, so section block and lot numbers. So they have filed with the county two separate and distinct numbers that identify them as different parcels. They had separate street addresses, and that mom's star exemption only covered the primary residence lot, the one that's not in dispute, and it didn't cover the adjacent lot. So that's some of the information or materials that the son had presented. The court in this case determined, based on all of the factors that had been presented to them, that the decedent did consider the lot an extension of her primary residence. And so it should be included in that specific distribution to the daughter Holly. So now the court is holding here that Holly is going to receive that vacant lot, the adjacent parcel, as part of the primary residence under that specific distribution. And the court discussed the reasons why and how they felt some of the information weighed a little more heavily than others. But they also addressed the fact that if Holly was required to share this lot with her brother, and at some point the brother wasn't interested in maintaining or keeping the lot, right, they'd have to go through some kind of a sale transaction, or Holly would be forced to buy out her brother, or, you know, any other number of things that basically is evidence of them disagreeing. And they didn't feel that the decedent would have wanted to put her children in that scenario where they're going to be forced to fight with each other or one buy the other out or any of these things. So the court kind of took a look at what the family situation might look like if they did require the lot to be shared, and they didn't think that the decedent would have wanted that for her children anyway. So the court's weighing heavily on what they believe the intent of the decedent is. The troublesome thing about this, and this is why we spend hours with you at the outset when we're putting your plan together, but also on an annual basis, is this could have been avoided had the language in the will been a little bit more specific, right? So even if they just said my primary residence located at, and maybe they say the street address and in parentheses the parcel number, if they had only intended for it to be the one parcel or refer to both parcels. So it would have only been a matter of a number of words to make a distinction and avoided all of this controversy between the children, which certainly cost them a fair bit more money to go through this separate proceeding to get this holding. So, you know, the words are important. The language is important. It's important that you guys disclose to us if you believe that things are held on separate lots or there might be something unique about a parcel. And that's why we spend so much time going through that with you. So it might frustrate you a little bit, but it's important on the back end. And we appreciate your cooperation with that year to year.
Right. And yeah, so this was careless drafting, I would call it. Counseling had some combination of these things because there were factors, you know, on both sides. This was not a slam dunk case, or it probably got it right, but it could have, you could argue the other way too. So without having more definitive information in the will, it's left again for a litigious kind of result. Not good for anybody, except for the daughter, I guess, at the end who got it, but she would have been happier if she didn't have to go through that trouble.
Yeah.
The other case to discuss is for the case called the Matter of Determination of the Ira Yohalam Irrevocable Trust. So here we had a trustee of an irrevocable trust who was not the spouse of the decedent. It was an independent person. He filed an uncontested petition asking the court to terminate the trust as uneconomical, which is one of the criteria in the Estate Powers and Trust Law, Section 7-1.9, which sets forth different bases for terminating a trust. And one of them is if it's uneconomical to continue the management of the trust. Hard to make an argument here that it was uneconomical when the trust was just under $950,000 at the time of the petition. So at the time of the decedent's death, the trust, which would have been the irrevocable trust, was divided into a marital and residuary trust, similar to the marital and family trust that we have in our revocable trust documents. The surviving spouse, the wife, was to receive income from both subtrusts, the marital and the residuary trust, and it was a typical principal distribution for maintenance, support, and health, or health, education, maintenance, however you want to craft it. It's all pretty similar language that we use. The trust further stated that upon the wife's subsequent death, the principal in the trust was to be distributed in equal shares to the couple's 2 adult children. The court denied this petition, would not allow for the termination of the trust. Why was that? Well, the court first of all noted that while the statute that I referenced allows for trusts of modest value to be terminated, where the administrative expenses, are going to eat into a significant amount of the trust income or principal, in this case, the trust had a not insignificant sum of $930,000. Even, 10 or 15,000 of annual commissions to a trustee would not be that much of a burden on the administration of the trust. So ultimately, the court said there was no proof that continued administration of the trust would in fact be uneconomical, which was the stated basis for the petition in the first place. And the court went on to say that the termination of the trust would contradict the purpose of providing for the surviving spouse during her lifetime, which was the stated disposition of the trust. Allowing for the early termination of the trust would, in the court's view, represent a significant departure from the trust purpose of providing income for her life during lifetime, with the principal, if any, going to the couple's 2 children until once the wife had passed. What's also important here, and this is similar to a case we discussed last year, all the parties involved, the spouse, the 2 kids, and the trustee, all were on board. No one contested allowing this to happen, the termination, that is. But the court says we don't care who's in favor and who isn't. We are guided by the law and what the trust says. And unless it meets a criteria for termination, we are not going to approve that termination. So, basically what I believe the facts of the case said is the wife was going to basically, upon termination, just give the assets to the 2 kids outright. And she was perfectly fine with it. But the court said, well, the guy who created the trust, your ex-husband, is not here to approve that. So we can't, go back in time and assume he would have agreed to do this. So you're stuck with what you have, live with it, and deal with it then. And that's what we have. So another interesting case.
Mm-hmm.
So that'll move us after those reports to the planning spotlight. Every year we'd like to take a bit of a deeper dive into a specific topic. And this year we're going to talk about Medicaid planning and Medicaid rules. We call this the nuts and bolts discussion. We visited this in past years. This is the 26th year now or so, or 25th year of doing these. But clearly this is one of the most important topics for the vast majority of clients. So, doing this every several years is always worth the exercise. So with that being said, I'll have Megan start the conversation.
Mm-hmm. So when we're talking about Medicaid, what we're talking about, and I'm sure you guys on this webinar all know this well enough, we're talking about how we're going to pay for long-term care and how we can qualify for the Medicaid benefit without truly impoverishing ourselves. And the idea here is that we want to try to preserve as much of our assets as possible so that it's not being spent on long-term care, or at least not entirely depleted on long-term care. And we can make sure that there's something left over for those people that we leave behind. So the Medicaid benefit, in order to be eligible for it, you do have to be able to demonstrate that you meet certain asset criteria, financial criteria primarily, and then they're going to take a look at your income as well. And so when we do our estate planning with our clients, we're doing estate planning with these Medicaid income and resource limits in mind so that we can strategize and try to protect and preserve assets. But many people, obviously not yourselves, but many people don't realize that there's proactive planning that can be done. And so they don't contact us for help until they suddenly need long-term care. They don't have the use of a trust or anything in place to protect assets proactively, but we can still protect assets even at the last minute. It's just usually not as much as we would have through a planning like your own using an irrevocable trust. But so it's important to understand the Medicaid income and resource levels so that we know what it is we're planning for and around so that we can be strategic with our decisions. These numbers change a little bit each year. So you're going to see on the screen the 2025 figures. They typically, except for the one that for income I'll get to in a minute, typically you're going to see these adjusted a little bit for inflation each year. So we often will see them increase. Now the limits on resources, the resources is referring to the countable assets that a person has in their name at the time they're applying for the long-term care Medicaid benefit. And so what an individual as of this year cannot exceed if they expect to qualify for Medicaid in assets is going to be $32,396 worth of assets. So that's the value of the countable assets. Now, typically the value of someone's primary residence is not counting towards this number. Assets that are in an irrevocable trust that's been in effect for, that the assets, I should say, have been funded to that trust for at least 5 years at the time of the application, those assets will not count towards this figure either. And generally our retirement accounts are not counting towards this figure, but pretty much everything else, every other non-trust asset that's still in the applicant's name, we're going to tally up the total value of those assets. And if it exceeds the $32,396, then this person is not eligible for Medicaid yet. So there's planning strategies that we'll use to make them eligible at that point, but they do have to be below this $32,000 threshold. Once they're eligible for Medicaid, we also have some limits on income. And so in New York, at least, it's not the income that's generally disqualifying an individual from qualifying for the Medicaid benefit. The non-institutionalized individual, meaning someone who's going to stay in their own home and they're going to have a caregiver come to them, or in an instance where they're in maybe an assisted living facility, anything that's not a nursing home situation, that applicant is allowed to keep $1,800 per month of their monthly income. The excess income that they have above the $1,800 can either be used to help pay for their care, whatever their care needs are, or it can be allocated to a separate pooled income trust, which is not something you set up in advance. You only set it up if you need it at the time you need it. And the pooled income trust allows the individual to continue to use that extra income above the $1,800 towards regular daily expenses and needs that they may have. Now, in a nursing home situation, you're going to see here on the screen that an individual who's in a nursing home and qualifying for Medicaid is only allowed to keep $50 per month of their income. This $50 number is a number that has not changed over the last many, many years. I don't know if we've ever seen it change. It hasn't changed during my career. And so they're only allowed to keep $50 per month of their income. All of the excess income would be contributed to the nursing home to assist with the payment of their care. And then the remaining nursing home bill, the balance of that bill, can be paid for using the Medicaid benefit. So it's not that the government takes the extra money, it's that it's being used, contributed towards the care, and then Medicaid will pay for any excess costs above that. Now, the $50 a month mark, that's pretty much the money they can keep there in their pocket or in their bank account. They are allowed to keep additional income that can be used towards insurance premiums, Medicare premiums, but because that's being spent on premiums, it's not money that's going to remain available to them. If we have an applicant that is married, we will also need to look at the assets and income that are in the, what we're calling here, the community spouse's name, the well spouse's name. So there's a maximum, a limit on the amount of assets or the value of assets that the community spouse can have. And that limit, also typically adjusted each year, is $157,920 value of assets that the community spouse can have and still allow for the applicant to qualify for Medicaid. The community spouse is also allowed to have up to $3,948 per month of income. And so the way the income works for a community spouse or a well spouse is that this is the amount that is determined that they pretty much need to survive on. So we don't want to remove their access to income up to the $3,948. So what happens in New York is that if the well spouse's income is below this $3,948 threshold, they're actually allowed to keep some of the applicant spouse's income up to the $3,948 threshold. And then anything in excess of that would be used to contribute towards the applicant spouse's care. However, if the well spouse's income all by themselves exceeds the $3,948, then they don't have to pay over their income towards their spouse's care, but they can keep all of their income in excess of the $3,948. So what we have in New York is something known as spousal refusal that allows for that kind of an adjustment, and it also applies to assets. So New York, we joke, is bad for a lot of things, but New York is very good for Medicaid eligibility because of this spousal refusal benefit that allows the well spouse to keep in excess of this asset threshold that you see here on the screen, and potentially keeping in excess of the income threshold as long as that income is the well spouse's income. So that's what we talk about here. Spousal refusal is available to us in New York. And so this is something that's not necessarily available in other states. I think Florida is another state that has some level of spousal refusal. There may be some question about whether Connecticut has it as well, but what it is when we submit that Medicaid application for the spouse who needs the care. Along with the application, we submit a document, a spousal refusal document, which is a signed statement by the well spouse saying that I acknowledge my assets or my income is in excess of these thresholds, but I don't want to contribute that towards my spouse's care. I want to keep that for myself. And then depending on what county the applicant is located in, the Department of Social Services in that county will respond to this spousal refusal in a few different ways. But the good news is that at least currently in our local counties, our Orange County and the surrounding counties, generally a spousal refusal is accepted completely and we don't get any pushback or negotiation or anything like that. But that does differ county to county. So under a spousal refusal or using a spousal refusal strategy, like we said, the well spouse is allowed to retain excess income and assets. So even though the threshold is there, they can actually exceed that threshold and the applicant spouse will still qualify for Medicaid. They'll still remain eligible. The third and fourth bullet talk about if we did get some kind of a response from DSS, which like I said, is not often in our county and surrounding counties, but other counties, it's more common. DSS can request a contribution. So in response to the spousal refusal, they can request a contribution of 25% of the excess income of that well spouse. So this is where they're saying, okay, I see what you're saying and you have this right to spousal refusal, but we'd still like for you to contribute some of that income to help offset this cost. And then the fourth bullet is describing that Department of Social Services also retains the right to file a lawsuit for any additional contributions. So like I said, some counties you will see this happen. They're commonplace in some counties. If Department of Social Services does file a lawsuit for additional contributions, they're only allowed to collect what they pay, what the Medicaid benefit pays for. And because Medicaid as a government benefit is actually paying what I'll consider a discounted rate, that they're not going to pay as much as a private individual would pay to a nursing facility, for example, they are going to be asking for a reimbursement of what they are paying, and that's always going to be less than the private pay rate. So even if DSS files this claim, the individual, the well spouse, is still going to pay less than had they just said, you know what, I give up. I'm just going to privately pay for the care because they're going to come after me anyway. So you're still able to get a discount using this strategy. So some of the advantages of spousal refusal, the community spouse might not get sued, right? And that's what I described happens here locally. We submit a spousal refusal and typically it's just accepted, the applicant is approved, and we never hear anything otherwise. No requests for additional contributions, no lawsuit seeking any additional funding. And like I said, the Medicaid reimbursement rate is a discounted rate. It's a fraction of what the private pay rate is. So even if the well spouse is required to pay some funds over to DSS, it's never going to be as much as they would have paid had they paid privately. So typically what we're looking at when especially when we're proactively planning, but certainly at the time someone is applying for Medicaid, what we're looking at is, have any gifts been made? And so right now, and Rich mentioned this before, but right now, the only time we're concerned about gifting occurring is when an individual is needing a nursing home. And that's because there's what's called a 5-year look back for nursing home Medicaid. And how that works is when someone submits a Medicaid application looking for payment for their nursing home bill, in addition to the regular application, they need to submit 5 years worth of financial statements. And that 5 years is what the Department of Social Services, the caseworkers, will comb through to see if there are any non-exempt transfers, any gifts that were made within that 5-year period. And what they'll do is they'll tally up all of those gifts that were made over that period of time, including transfers to children, other individuals, and even to irrevocable trusts if it's made within the 5-year period. And based on that total number of non-exempt transfers of gifts that they find, they're going to use a formula to calculate what's called a penalty period, a period of time where the applicant, although technically eligible today, is not going to be eligible or receive a Medicaid benefit based on the calculation used in that formula. And that's to penalize them for those gifts that were made in that 5-year period, that 5-year look back. So as Rich described before, there is the potential always that the community look back, or the community Medicaid look back, will become effective. If it does become effective, it'll be a 2.5-year period. However, we haven't heard any updates on this, and we don't know if this is something that will ever come to fruition. So it's on the books. It's always something that we do have to be mindful of and look out for. But right now, transfers can be made right up until the time someone needs community level care, and there's no penalty period that would be incurred for that. It's just nursing home care.
Right. Two things I'll toss in here. One is that we often will hear from people in the public, oh, I hear there's going to be a 7-year look back for nursing home. There's zero truth to that. There's nothing in the works to make that happen. That's one of those great urban legends that I have no idea where it derived from. It's out there, but there's nothing to tell us if that's going to happen. Second thing is, even though we don't have to worry about penalties and look back for community Medicaid presently, we always have to be mindful that when someone is getting community Medicaid services in their home, there's a fairly significant likelihood that they are going to end up in a nursing home within this 5-year look back. So when we do any lifetime transfers for community Medicaid eligibility, we want to make sure it's done in a way that if we have to undo the gift later and revert to what we'll talk about in a moment, the half a loaf strategy, the money hasn't been spent on the casino up in Monticello or on FanDuel or any of these other places, or at the local drinking establishment.
Yep, that's a great point.
So there you go. So what are some of the exceptions to the penalty rules? So any amount of resources may be transferred between spouses without imposition of a penalty. One of the biggest exemptions that we have is having having a spouse, right? So there's some downsides to having a spouse, but there's some good parts to having a spouse. And we could discuss that, the merits of both at any time you want, but there you go. This is one of the benefits of having a spouse. You can give them all your assets and don't worry about a Medicaid penalty. What you can't do though is give your assets to your spouse and then, thereafter, immediately thereafter, any of the spouse then gives the assets to your kids or anyone else. That will create a penalty. So either spouse, either as a couple or individually giving it to a third party, unless that third party transfer is also exempt, will create a penalty. However, once we get a person Medicaid approved and 30 days has passed from that time, the spouse to whom assets have been transferred can then engage in planning of their own, which could involve transfers to third parties without revoking or canceling the Medicaid eligibility of the spouse who got approval in the first place. What are their exempt transfers? Well, one is dealing with disabled children or grandchildren. We can have our clients transfer assets to a supplemental needs trust for the benefit of a disabled child or grandchild, as long as they're under 65, which you would think they would be. And if they are disabled, that will not create a penalty. However, it's not exactly a free lunch, because when that trust beneficiary someday dies, if there's anything left in the trust, there will be a payback requirement to Medicaid, which is not usually the case when we are using what's called a third-party trust, funded by one person for the benefit of the other. But the theory here, the public policy argument, is that we are allowing you, mom or dad or grandma and grandpa, to transfer assets to your disabled child or grandchild so that they have more resources since they're younger and likely have a long lifespan. We'll let you get Medicaid immediately for yourself, but then when that beneficiary dies, before it goes to your family, we get paid back first. So it's a good solution, not maybe perfect, but better than some of the alternatives. There are special rules applying to the primary residence. Your primary residence can be transferred to any of the people listed on the screen without a penalty. Your spouse, that's like any asset that I covered a moment ago. A child under the age of 21. So I call this the Tony Randall rule or Mick Jagger rule. Talking about some old guy who has a kid when they're 80 years old. Doesn't happen often, but occasionally we get a case where a Medicaid applicant will have a child under 21. We can, in that case, transfer title to that home, whether the child is living there or not, without a penalty. Another exemption is a transfer to a blind or disabled child of any age. So it doesn't have to go in a supplemental needs trust specifically. If a person is just under SSDIs, which is not a means tested program, we can put the house in their name without loss of any benefits to them, and there's no payback requirement in that case. The fourth one is one that actually is more common than you think: transferring to a sibling who has an equity interest in the house, so long as they lived in the home for at least 1 year. So we occasionally have these elderly siblings who will live together. We had a famous couple of sisters. They were identical twins who came in with identical outfits all the time, except one would have a red top and one would have a blue top, right, Megan?
Right. Yep.
Quite, they were always, you never forgot when those people came in. And they were lovely women. Unfortunately, they're both passed since then. But regardless, they lived together their whole lives. And if one of them had needed long-term care, we could have transferred home to the other, even if they weren't already on the deed, as long as they contributed to the costs of expenditures and maintenance of the home. Under the Medicaid law or rules, the regs, having an equity interest doesn't actually mean that the other sibling is on title, as long as they've been paying expenses. That seems to fit the bill. And the last one, and the one that's probably the most common other than the spousal transfer, is the ability to transfer home to what's deemed a caretaker child who has lived in their parents' home for at least 2 years before the Medicaid application is submitted. So A common scenario, parent is a widow. She's living on her own. She, has a fall, goes to the hospital, they get her home. And of course, one or more of the children are concerned. So one of the kids decides, all right, I'm going to move in with mom for a while. And they end up living there for quite a while, taking mom to her doctors, doing the household stuff, making sure mom is well cared for. If at least 2 years has elapsed and then mom finally, can't be cared for at home and goes to nursing home, legal title, a deed can be drafted to convey the house to that adult caretaker child without creating a penalty, even if it's within the 5 year look back. So it happens often. It raises some other potential complication if there are other children who were supposed to be beneficiaries. Title can only go into the caretaker child. Now, once it's in his or her name, nothing stops them from adding siblings to the deed, etc. But it can't be the first go round. It has to be after the Medicaid application has been submitted. Not as good as proactive planning, certainly using a Medicaid trust and so on. But when you're in a pinch, you're looking for any angle you can, and this is one that we will use when the situation warrants it. So those are the residential rules. Some other exceptions to the transfer penalties in general. If you can sell an asset for fair market value. So you have trying to think of an example, a valuable car, and it's not when you get one exempt vehicle, you have a second vehicle, you sell for 50,000. Not a penalized transfer, but you really haven't accomplished anything. You've just taken one asset and swapped it for cash, which will still be part of your accountable resources. So not really a very helpful one. The next one is more useful. Assets that are transferred, quote, exclusively for a purpose other than to qualify for Medicaid, as it says in the statute. What does that mean? So let's say 78-year-old woman and otherwise seems in good health. Her 43-year-old son is going through divorce. He doesn't have enough money to pay the fancy pants lawyers who need to get paid, obviously. And so mom loans him $30,000 for the retainment. Not loans, gives him $30,000 for the retainment. I have plenty. I'm going to give you money. All right. And because she wants to be fair to the other two kids, she gives each of them 30,000 to even it out. So she's giving away 90,000. 3 years passes. She has a massive stroke. Goes to a nursing home. Now that 90,000 total transfer is clearly made within the look back period. But if you can show factually that when she made the transfer, she was not in declining health of any significant nature, no immediate prospect of requiring long-term care, and she did it for the kind of reason that can be supported, gave one to my son for divorce, the other two just to even out the gifts, you can make a successful argument, and there's plenty of case law and fair hearings about this, that $90,000 transfer was for a purpose other than to qualify for Medicaid and therefore should not result in a penalty. You'll probably be denied on the front end. You have to go to a fair hearing, which is an administrative hearing, but you are very possibly going to prevail and save that money right then and there. The next bullet point is the imposition of a penalty would cause an undue hardship. Well, of course, a penalty will always cause a hardship. The question is whether it's an undue one. Where this might come up is only in the case, remember we talked about someone, let's say someone's getting community Medicaid. We put the money in the kid's name or names. So there are two of them. They have a joint account, and there's agreement among everyone, even emails. Oh yeah, we're going to save this for mom in case she needs a nursing home within the 5 years. Well, lo and behold, one of the kids a year later empties out the account, goes to the casino and blows the whole thing. No one knows about it until we're applying for Medicaid for mom, 3 years later. Well, if you can show factually that's what's transpired, you might be able to make a case. It's a long shot, but you might be able to make the case that mom shouldn't be penalized because the daughter screwed up what we were trying to do in the first place. And then the last one, which is a very common thing and not controversial, is you can use money to pay for a pre-need burial trust for the applicant and also their immediate family, which includes children, spouses of children, grandchildren, etc. not a very common thing to do. Usually people are going to buy their own pre-need burial account or cremation account for them and their spouse if there is one. But there was one case we had a year or two ago where we thought we had all our ducks in a row, and it turned out when we were filing for Medicaid, there was this unknown life insurance policy with, I'll use the number, 20,000 cash surrender value in the applicant's name that would have created a penalty, and we would have screwed up all our planning. So what we did with that extra 20 is we used that to buy pre-need burial contract for the two kids, son and daughter, who were only in their 40s at the time. But that was one effective way of transferring that money without creating a penalty. Again, not a common thing to do, but it's always available if we need to do it. So I think those are all the penalty rule exceptions. So now Megan's going to describe how we've gone through all the possible exemptions we have. We either had some, one, two, or none. And now we're going to deal with, okay, what do we do if we have nothing else we can do with exempt transfers?
Like we said before, there's the potential for the community look back, but primarily right now when we're doing our planning, we're dealing with the 5-year look back for nursing home care. And this is going to be for non-exempt transfers, as we've described. And as I mentioned before, we never know when this is going to be effective, right? We don't know what year it's going to start that we have to stop making the gifts, stop making the transfers, because the year that we start with is going to be the date of the application for the nursing home Medicaid, and then go working backwards for 5 years in the case of a nursing home. So we always want to be very careful with our transfers, but sometimes that means that transfers will fall within that look back period. Excuse me. So this brings us to what's called the penalty period. And as I described before, what Department of Social Services does is when they look through those asset statements, they're going to be looking for these non-exempt transfers. And it's basically any unexplained transfer. So the burden is on the applicant to be able to demonstrate that this fell within an exception, or it was for some kind of plausible use. It was for the purchase of a good or a service or something like that. So they're going to be looking at cash transfers, checks made to individuals with no indication for what that is, and just general gifts. They're going to consider all of those gifts. And like I said before, they're going to use a formula to use the value of those total gifts that occurred during that look back period to determine what the penalty period is, a period of time that, while technically this applicant's assets are below the threshold, how they got there is a way that we don't like, Department of Services doesn't like. And so we're going to incur a penalty based on the value of the uncompensated, non-exempt transfers that have occurred during that look back period.
Yeah, before we proceed, we do have a question. The question is, for someone who's not on Medicaid and wants to apply, what resource exemptions do not account towards income eligibility? For example, pension, Social Security, are they included? Well, you're really sort of comparing, bringing apples to oranges. Resources are assets, it's not part of your income. So when they look at resources, they look at things like real estate, bank accounts, tangible assets of that nature, and intangible financial accounts. Income is Social Security, IRA distributions, pensions, things of that, recurring monthly income. Those will go into those income numbers. So for example, in the community setting, if you're the applicant, your total income, they're going to look at your income exemption is $1,800. So if you have Social Security and a pension totaling $4,000, you're going to be in excess of the exemption by $2,200. Doesn't mean you won't be eligible for Medicaid, just means you may have a contribution. If you have no spouse, you're going to kick in that extra $2,200. If you're in a nursing home, you may have to kick in $3,950 of your $4,000 a monthly income. So hopefully that makes sense. If there is a community spouse, Megan mentioned that $3,948.50 exemption, that the income that you have may go towards your spouse if they are below that $3,948. But there are really two categories of things to consider: resources on one side, asset or income on the other. What Megan is just talking about now in the penalty period is solely about resources. So
Right.
hopefully that's the case, so we answer that question.
Right. So whenever we see transfers of assets, resources that occurred within that look back period, that's when we're going to find that we are incurring a penalty period as punishment for these transfers. And how the penalty period is determined is, like I said, using a formula, and DSS is going to divide the total amount of gifts that were made within the 5-year period by what's called the average monthly cost of nursing home care, which is established by New York State, and it's different regionally. So we'll get to see that on the next slide.
Yeah.
So here we see what's called the regional rates. So this is what's used as the divisor when we're trying to determine what the penalty period is going to be, or DSS is making that determination. We fall into the Northern Metropolitan region, which is in red on the screen. So we see what the regional rate for our region is going to be is $14,569. That's what they're saying that nursing homes cost in our area. It's quite a high number. It's pretty accurate, honestly. You will find some that are lower technically, and you'll find some that are higher for sure. But this is going to be the average that they're using just to be able to use this in a calculation, in a formula. And it's actually to our benefit, or the applicant's benefit, for this number to be as high as possible, because it's going to result in a shorter penalty period. So I think the way the math works is that if an individual gave away, so these are unexplained, uncompensated gifts over the last 5-year period. If they gave away $100,000 over that period, good for the recipients. But what that means is that when we use this divisor, we plug it into the formula, it's just a smidge under a 7-month penalty period. So DSS says, I've received your application, I've reviewed your financials, the assets, and it looks like you gave away $100,000 with no explanation, no defense. We all agree you gave away $100,000. So because of that, even though you're technically eligible today, you're below the $32,000 threshold today, we're not going to pay for your first 7 months thereabouts of nursing home care. So you're going to have to figure out how to pay for that care yourself, because we're not going to pay for it. After that penalty period expires, we will begin to pay for your care. So what's important is that the start of the penalty period doesn't actually begin to run. We don't start that 7-month period in that example until the application, the Medicaid application, is actually filed, and provided that the applicant was otherwise eligible for Medicaid, so that they meet all the other criteria, their assets are below the $32,000 threshold, and the application was submitted to the Department of Social Services. And this is an interesting point, because I get the question sometimes from people that, can't we just start this penalty period early, right? Like, we know that it's going to happen, so can't we just get it going now? And the answer is not really, not unless we are otherwise eligible and we file this application with the expectation that this person does have a care need currently. So that's important as well. We have to keep that in mind, that the application really needs to be filed before we start counting against this penalty period. For community Medicaid eligibility, the applicant has to not only show that they meet the financial criteria, but they do have to go through what's considered a functional assessment, an assessment that determines that that individual truly has a care need. They're beginning to need the care. And again, I do sometimes get the question that family members are expecting there's going to be a future need for care, but mom or dad doesn't really need assistance just yet. It's just that they want to get ahead of it. So maybe the kinds of things that they say they need assistance with is, it'd be great to have someone else cook the meals instead of the individual or the family members helping out, lay out medications, sort of the more minor assistance tasks, but not really care needs. And so in order to determine if a person is eligible for community level care in their own home or assisted living, we not only have to demonstrate that financial need, but then they're going to go through a series of assessments to truly make sure they're starting to need the care. So what we're calling on this slide crisis planning. This is the kind of planning that we would use at the time someone is needing the care. So they're now, let's say, at the door of the nursing home. They've had some kind of a medical issue, and so we know that they're going to be entering a facility. And whether or not they've done proactive planning, this strategy can be used. It's just that when someone's done some proactive planning, like yourselves, you've already structured maybe an irrevocable trust to help assist with the protection of assets. It just means that that much more is already protected, and we don't have to use the half a loaf strategy for those assets that are safe within that irrevocable trust and have been there for at least 5 years. For your non-trust assets, or for those individuals who never did proactive planning, and this is the first they're hearing about Medicaid, we can consider what's called a half a loaf plan. So we're taking a look at a person who has assets in excess of the $32,000 threshold, so they don't yet qualify for Medicaid, but the family agrees that they don't want to lose all of these assets. They don't want to be required to spend them all on the applicant's care before Medicaid begins to pay the benefit. So then we consider this half a loaf crisis Medicaid planning, which currently we're using in nursing home settings just because we don't need to use it typically for community settings. But how it works is, and we'll use the example that's on the screen, parent in this case has $200,000 of non-exempt assets or gifts or assets that we're taking into consideration. The strategy would require that we move this money out of their name. And red flags should be going up in your minds. Well, if we move this money, right, then we're going to incur a penalty. Well, part of the strategy is moving the full amount. However, about half of the amount, and the specific figures are going to depend very much on the person's income and other factors. But for the example, we'll say about half of the amount that's being moved is going to be considered a gift. And true, because it's a gift, we are going to incur a penalty period. So the other half of the funds that are being moved are going to be considered a loan. So usually we'll have the participation of an adult child or a trusted individual who will help us with this transaction. And the parent will loan the half of the funds to that adult child. This loan is a structured loan. It has paperwork involved with it. It's documented. It's done according to very specific terms that includes interest on the loan. And so the loan portion of this transfer is not going to create a penalty period. And the reason that we use a loan is because the loan payments from the child back to the parent are going to be structured in a way that covers the penalty period that the parent is now incurring for the other half of the transfer, the gifted portion of the transfer. So in the example where we have $200,000 and $100,000 of that is considered a gift, that means that the parent is going to incur a 6.9 month penalty period. So the other $100,000 that's considered part of the loan is going to be structured in a way that the child is going to make payments back to their parent over that almost 7-month period. Those payments that are considered loan payments are going to be coupled with the parent's regular income. So like their Social Security, their pension, other sources of income. And together the loan payments plus the other sources of income should be sufficient to pay for that parent's 7-month penalty period. So they're privately paying for their care for 7 months, but through this strategy, we're able to save at least half of the assets for the gifted portion of the strategy. So it's very technical. There's a lot of numbers and figures that are involved in this in determining the precise numbers, the precise amount that can be used as part of the gift versus the amount of the loan. And so this is typically something that we don't want people to try to do on their own at home because you will very likely not be successful.
Yeah, almost guaranteed you're not going to be.
Yeah.
Yeah, and so people say, well, why don't we just make a gift of 200,000? Well, if you do that, you're going to double your penalty to about 14 months, 13.8, and you won't have the funds left to do it. So by splitting the difference, or the half a loaf, as we call it, you get to maximize the gift portion and minimize the out-of-pocket expense to the degree possible. So this is our go-to crisis planning strategy when everything else has been taken off the table. So to be Medicaid qualified, the loan has to be structured, as Megan said, very, very carefully. Must have an interest component. Usually we use what's called the applicable federal rate, which is about the lowest rate you can use without being treated as a gift. must be repaid within the parent's life expectancy, or the client if it's not a parent, which usually isn't an issue. These are typically short-term loans. Like on the prior example, it's a 7-month loan. Even with a, $500,000 gift loan strategy, 250,000, we're only talking maybe a year and a half of loan payments. And unless they're 110 years old, the life expectancy is going to be at least 4 or 5 or 6 years. It must be non-cancelable or must be repaid in equal installments. Back in the day, when Megan was still in diapers, probably, we used to do loans with balloon payments. We used to do very low, $100 a month for 10 years. And then in year, 11, we do a balloon when we figured mom was already dead by then, so we could save more money. Can't do that anymore. Has to be an equal installment. Has to say that the loan is non-cancelable on the death of the parent, which frankly doesn't really matter, because if there's anything left that's to be repaid after the applicant has died, that means they've actually never gone on Medicaid. We haven't gotten through the penalty period. So as a practical matter, the money is just basically forgiven, but it has to say non-cancelable. And lastly, and this is very important, it has to be a non-assignable note. The average note that we all sign when we purchase a home and get a mortgage is an assignable mortgage or note, because the original lender, and again, I haven't been in the real estate world in a long time, but back in the heyday, loans were sold even before you left the closing. I think there's still a large secondary loan mortgage market, quite not as active as it was before the crash in 08, 07, 08. But regardless, all your mortgage loans are assignable. This one has to specifically say this note cannot be transferred, conveyed, assigned to anybody. Because the theory is, if you could sell your note, so let's say the note was for $100,000. If you could sell it and recognize 100,000 of cash, DSS would say, well, it's a liquid asset. You can pay that over to us. If it's non-assignable, the only thing you're going to be entitled to are those monthly note payments. So that's why you can't do this at home, kind of thing. We'll talk about personal service contracts for a moment. These are very useful agreements or arrangements. Remember, we talked about daughter comes in to live with mom and, can get the house after the 2-year period. But what happens if the daughter has to leave her job entirely or reduce her hours to help take care of mom? She's losing income. Why not pay her? Well, you can, but because she's a related family member, if the payments aren't pursuant to a written personal service agreement, the Department of Social Services will consider those payments later on as gifts that will be subject to the gift penalty rules. Because the legal public policy rule is that if you are taking care of a parent and is not a written agreement as a contract, it is deemed you are doing so for love and affection. And therefore, if you've gotten payments for it without a written contract, those are gifts. So to take that out of the gift mode and treat it as regular old compensation, a personal service contract is required, which is a written agreement between the caregiver and the parent for the compensation to the caregiver for providing care and assistance to the family member. Typically a parent, but it could be an aunt or uncle, grandma, whatever. Must be a written agreement for reasonable compensation. If the market says your average care aide is going to get paid $25, if it's an on the books kind of deal, you can charge $25 for being a care aide. You can't charge $80 an hour. To make this stand up in the Medicaid application context, you must keep good records. When we do caregiver agreements, we provide our clients with logs so they can keep written records of what they did. So literally, 9 a.m., got mom out of bed, showered and dressed, fed breakfast, hour and a half, whatever it is. Keep a log like you're doing a timesheet. And the caregiver should be paying income taxes on the payments, getting, filing tax paperwork and the like. Now, DSS, in our experience, isn't going to check your tax records and so on and so forth, but you really, to button this up, you should be getting compensation and paying taxes on the money. If you do all those things, then if you're getting paid 60,000-70,000 a year to be mom's caregiver, which is a very reasonable figure and below market, especially if you're doing it full time, you can get $100,000. No one's going to gripe about that. Those will not create penalties if it's under the written caregiver agreement. Last thing, I think it's the last thing, powers of attorney. We always emphasize these. All of you have powers of attorney that we've done for you. We've updated them over the years when the forms change and your circumstances require it. Every power of attorney we do has a gifting power that allows us. So if you lose your marbles, have a stroke, your agent is going to be able to engage in all these strategies, do a half a loaf plan, sign notes on your behalf, fund and create trusts, enter into caregiver agreements. Anything you could do at a crisis mode, your agent is going to have that same authority. Takes us out of the realm of requiring an Article 81 guardianship, etc., etc. We don't want to go through guardianships. They're expensive and time consuming. So that covers it. I had the one question, and before we sign off for our day, hopefully you've gotten some good information. You will be contacted most likely by Dominique, our new legal assistant, to schedule your update signing if you haven't had that scheduled already. And as always, Megan and I and our staff are here to help you with any questions you may have going forward. As participants in our maintenance, you can reach out to us and you won't get a bill in the mail for that. Megan, anything to add as we wrap up here today?
Oh, just appreciate everyone's participation. And as Rich said, if you have questions that can't wait until that restatement meeting, you're always welcome to reach out. You'll be meeting this year with either myself or with Rich. So, when Dominique contacts you, she'll let you know what our availability is. And that way you can schedule appropriately, but it'll be with one of the two of us.
Right. And our hope is by 2026, when Max is trained a little and up to speed, he'll probably be your primary meeting contact for that process. And just as a reminder, we, as long as the technology worked, which it seemed to, there should be a recording of this program up on our website in a few days. There's a video dropped from a drop-down menu, and there's other videos there you can watch too if you are enchanted with our video skills and so on and so forth. So with that being said, we're happy to have had you join us today, and we wish you a lovely day. Of course, my computer has these little notifications, says we're in for 2 inches of rain. So more to come. But better days are ahead, I'm sure. Well, thank you all and have a great day and enjoy life. Bye-bye.